Hello, and welcome to the Hildebrand Law Firm topic for today. I'm Matt Kaplan,
And I'm attorney Derek Darren.
and we have Derek here again for Kirsten. What are the chances? It's the same thing. Derek is replacing Kirsten. Chances are very high, considering we recorded this video about 5 minutes after we stopped recording the previous video. But that is the wonders of Hollywood. So we are here today to talk a little bit more about probate with Derek. Derek is our probate king here at Hildebrand Law Firm. And in the last video, he discussed very elegantly and very excitingly about the whole process of probate in under 10 minutes. But here he's going to field some common objections that clients give us or some common questions that clients give us about certain accounts. Will that go through probate? Doesn't this avoid probate? Does it not? Who knows? We shall see. So, Derek, first account I want to get started with is the wonderful joint accounts.
Yes.
Spouses have joint accounts all the time. People come to me and they say, well, I'm on a joint account with my spouse, so if my spouse passes away, I'll be totally fine, and vice versa. I guess talk a little bit about, is that the case? Is that not the case? Have you heard any stories or any issues with that? Or what kind of stuff does that bring up in a probate situation?
Sure. So joint accounts, especially with spouses, they tend to be okay, except for the fact when you have spouses who pass away, for example, within 4 days of each other, like I had in a recent case. Unfortunately, what that means then is that there's actually a statutory requirement that they survive by 5 days in order for that joint account to be effective for probate purposes. So in other words, what we had to do in that case is we actually had to open up probates for both husband and wife in that case to transfer a bank account to the personal representative who then distributed to the heirs. But you see a lot of issues as well with joint accounts when it's not between spouses. There's a ever prevailing area of law now called the convenience account, and I've seen quite a few of these cases come up recently for litigation, where basically instead of doing a proper estate plan, instead of doing a power of attorney through a licensed attorney in the state of Wisconsin, including Hildebrand Law Firm, an individual will choose to simply name their oldest child or their trusted child or their most local child as a joint owner on an account, which causes a ton of confusion when mom or dad or whoever the original owner was passes away. As I mentioned, a convenience account is something in Wisconsin that has come to the forefront more than previous years, where it's an account for the convenience of the original owner. In other words, when mom gets older, she can't necessarily go to the bank. Mom adds a child to the bank account as a joint owner. That child then immediately, according to the bank and according to the law, has all rights of deposit, withdrawal, and etc. to use those funds. I have had a case where, unfortunately, one of the trusted children went and withdrew all of those funds while mom was still alive, resulting in litigation. And mom was ultimately able to get that account back after significant legal fees. I've also seen the convenience account case where oldest daughter was named as a joint owner on an account, and when mom unexpectedly passed away, there was a lot of questions between the 4 other siblings about how did mom actually want this account to be treated? Did she want it to actually convey rights of survivorship to that surviving daughter? And so again, all of those areas of law lead to litigation, especially in the area of joint accounts.
Okay, no, very interesting. And so when you're on a convenience account with mom, say son is on a convenience account with mom, does that mean that the account now does that make him just an authorized signer, or is it just as if him and his mom share an account? Which one?
So a convenience account is based on statute. Basically, in Wisconsin, there's a statute that says a joint account conveys rights of survivorship to the second party. So in other words, upon the death of one party, it transfers automatically to the second one, unless there is a clear intent by the original owner that there should have been a different purpose or that there should not have been survivorship. There is no sort of default for that. The only way to establish a convenience account is to go to the court and say, hey, mom clearly did not intend for her life savings to go just to one of the children. She loved all of her children equally. Oftentimes, mom will at least have a will that says, here's what I want to happen with my assets. And most often it's split amongst the kids. So it does lead to a bunch of issues with regard to having to go in front of a judge, having to go to court to undo that sort of survivorship provision.
Okay, so it sounds like something that's easily done at the bank level, but there's seems to be a decent amount of potential pitfalls should something go wrong afterwards, right?
Correct. There's
Okay.
nothing at the bank level that differentiates a joint account with a convenience account. The
Okay.
bank will simply accept a death certificate of the deceased and they'll say, here you go, the account is now yours.
Okay. No, that makes total sense. So the next account that a lot of people have that they talk to me about is accounts with designated beneficiaries. And so what would those be? 401ks, life insurance, annuities, any uh, any brokerage accounts that you have, pretty much any financial account that you have, you could have a designated beneficiary. I guess what are some of the things to consider or pitfalls of just relying on designated beneficiaries?
And the issue with designated beneficiaries, also called payable on death beneficiaries, I will sometimes abbreviate that as a POD beneficiary. And then I won't catch myself when I'm doing that. So people are looking at me confused.
Not to be confused with the band POD from the early
Yes,
2000s.
correct. Yes. Youth of a Nation. Is that what
Yes,
they did?
they were
Yes.
actually a Christian
Yes.
rock band, which I
Okay.
discovered recently.
There you go.
How great is that?
So great. So the POD accounts, some of the pitfalls. First of all, you see often a person name PODs on their bank account. So let's say mom has a $20,000 bank account that's sitting out there, names all three of her children as PODs. The goal is obviously then to avoid probate and to avoid any sort of dispute amongst the kids about what mom's wishes were. Unfortunately, I have also seen that case where one of the POD beneficiaries wants to claim their money, is on top of it, and wants to have that withdrawn. And so their 1/3 share of that $20,000 account is there. They filed all the paperwork that the bank asked them to file to get that out. But the bank says, no, you actually need to have all three payable on death beneficiaries pay that out.
Mm.
So all three of them have to sign and turn in their documentation. A lot of times to just the same branch of the bank so that the banks understand what's going on. And so, yeah, I've seen that case as well where you have one person who wants to cash it out, who's filed their stuff, but has to sit and wait on the others who sometimes are out of state or out of touch or just don't have any motivation for whatever reason to go and access those funds. So that tends to cause problems as well, just on a practical level with banks.
So what if one of the people that you're sharing it with is out of state, out of touch? You can't get a hold of them at all.
Yeah,
What can you do?
a lot of times the banks will make you keep the funds there. In theory, there's probably some sort of court intervention that you could seek to go in front of a judge to free that up. But a lot of banks will say, no, we're not doing anything on it until and unless we get all three forms sent out. So a lot of times it's just stuck and frozen.
And what happens if, let's say, one of the designated beneficiaries predeceased the account owner?
Yep.
What happens in that situation?
Yeah, it certainly causes confusion for the bank. A lot of times they can go ahead and just pay that out to, in the example I used, if one of the three is predeceased, a lot of times they can pay that out to the beneficiaries, to the remaining two. But it does cause certainly confusion amongst the bank. And then obviously they're asking for a whole new set of paperwork as well to show that that person's actually deceased.
Okay, so it just sounds like although some people do this to try to make it simpler, as long as everything goes according to plan, which as we know, everything always goes according to plan. But as long as everything goes okay, then you probably are gonna be fine. But the issue is that percentage of time and where things don't totally go okay.
Yeah, and even when you have the funds or if you're named as a POD, a lot of times you see someone who owes someone else a bunch of money. If they're a POD beneficiary and say they owe the federal government for back taxes, the federal government can go and intercept that immediately. So a lot of times it causes issues at the time of claiming. That's why people don't like to claim it. But even more so, the joke we always say is POD accounts probably work fine for 40 or 50% of the people out there. Well, why would you ever do anything that's only going to work for you 40 or 50% of the time? It just does not make sense to do it that way. So, yeah, obviously for the clarity and the ability to quickly obtain and manage those funds, we always recommend putting it into a trust.
Yet I still hit my driver every time on a par four, even though I would love 30% of the time for it to go straight. But so this is going to be part one. We're going to split this up. Part two, we're going to talk about the home and how that can work if it's not inside of a trust and how that works with probate. So make sure you come back for part two of that. But this is part one. I want to thank attorney Derek Darren for joining us. You will see him again very shortly in part two. And just know that at Hildebrand Law Firm, we're always here to protect your today and your tomorrow. Thank you.